President Trump cannot continue to use the 1798 Alien Enemies Act to quickly deport migrants, at least not right now. That's according to this appeals court ruling that just came down. In this 2-1 ruling, the appeals court said the D.C. federal judge who initially issued the temporary restraining order that blocked the Trump administration was correct. Judge Henderson wrote, at this early stage, the government has yet to show a likelihood of success on the merits. The equities favor the plaintiffs, and the district court entered the TROs for a quintessentially valid purpose: to protect its remedial authority long enough to consider the parties' arguments. The majority was made up by a judge who was appointed by President Obama and another judge appointed by President George H.W. Bush. The two of them said that the D.C. federal court judge, James Boasberg's temporary restraining order does not stop the Trump administration from enforcing or carrying out their immigration policy. It just puts a short pause on the Trump administration actions so the judicial branch of government can review the legality of Trump's enactment of this rare 1700s law that's only been used 3 other times in our country's history. The Trump administration continues to argue that the president is the ultimate authority here, that this is a national security matter and no judge has the right to get in his way. The appeals court said, not so fast. Judicial review has always been available to non-citizens detained or removed under the AEA, Alien Enemies Act. During the War of 1812, Chief Justice John Marshall and Federal District Judge St. George Tucker ordered a British subject released because the local marshal had acted beyond his delegated authority by detaining the plaintiff without proper notice. The court went on to say the one thing that is not tolerable is for the government to seek from this court a stay of an order that the government at the very same time is telling the district court is not an order with which compliance was ever required. Heads, the government wins; tails, the district court loses is no way to obtain the exceptional relief of a TRO stay. So in this ruling, the appeals court majority really goes into a lot of detail about whether Trump can even invoke the Alien Enemies Act because there's no declared war that the United States is involved in. They talk about how these Venezuelans were deported, who they are, whether they were given proper notice that Trump was invoking this Alien Enemies Act, and whether they should have been deported at all. The one judge who dissented was a Trump appointee. Judge Walker agreed with the majority, though, that the Trump administration is wrong. He said, yeah, the judicial branch absolutely has the right to review this action. But he said Judge Boasberg's temporary restraining order should be reversed, not because the Trump administration is correct in its application of the Alien Enemies Act, but because that judge says the plaintiffs are actually suing in the wrong court. He said they should be suing in Texas, where they were first detained, not in Washington, D.C. Now, it's likely the Trump administration is going to appeal this ruling to the United States Supreme Court. Whether they're successful there, unclear. But in the meantime, this case is going to continue to play out in Judge Boasberg's courtroom in Washington, D.C. And right now, he is weighing whether to make that temporary restraining order a permanent block on the Trump administration's use of the Alien Enemies Act. He's also weighing whether the Trump administration violated his temporary restraining order when they allowed those migrant deportation flights to continue despite the judge's order to turn the planes around or ground them. So if you want to read this brand new ruling from the appeals court, I am going to email it out to you tonight in my Facts HQ email, so make sure you sign yourself up.